Once again, British Columbians are left in the dark about land rights after many of us were shocked to learn about not one, but three different agreements that were signed quietly between the Liberal government and the Musqueam band out in British Columbia. One of those agreements gives the band that governs only 1,400 people control over the fisheries. The other one gives them more control over waterways. And the other one established Aboriginal title for them over much of Greater Vancouver. We're talking Vancouver, going through part of Coquitlam, Burnaby, and more, and more. But what does all of this mean for private property rights? I'm Drea Humphrey with Rebel News, and today I bring you an interview with an Aboriginal law expert, Thomas Isaac.
I don't know how much more the BC economy can take of this, and these are self-inflicted wounds by our democratically elected governments.
Since the BC Supreme Court last year determined that Aboriginal title exists over and above fee simple, aka private property title, it's no doubt that people are very concerned about these quiet deals, in this case, happening with the Liberal government. But before I even get into private property rights, can I just make something clear? Even public land rights should matter to all. For example, the fisheries. This is an industry that involves tourism. It brings money into our province, especially in small port communities. It's something I've been shedding light on because sport fishers, recreational fishers, they are very concerned as they're seeing more control being given by the government, potentially to commercial and First Nations. First Nations who represent a very small amount of British Columbians and who the vast majority of British Columbians cannot vote for or against. So even Crown land is a concern to all. But in this case, when it comes to private property rights, well, the Liberal MP, Rebecca Alty, who is also the Minister of Crown and Indigenous Relations, well, she says, don't sweat it. You're all good. Trust me, bro. Don't worry. It's not about private property rights. That's what a representative from the Musqueam band is also saying. This isn't about private property rights. So yes, all land rights matter. So what is the Premier of British Columbia, David Eby, saying? He's saying he knew nothing about these agreements.
To the best of my understanding, the provincial government was not briefed at the political level on this. I can't say whether or not at this stage whether any public service members had line of sight to it. I certainly didn't.
Except shortly after that, his office came out and said, actually, Premier David Eby was present at the event celebrating the agreement, and yet still claims to have no clue what it was about. So that says a lot for our David Know-Nothing Eby Premier here.
I was honored and glad to be attending. I absolutely sat in the front row. I was glad to see the federal government working with the Musqueam people.
So we are to believe that the Premier of this province just randomly walked into a signing ceremony and had zero idea what was going on. Give me an absolute break, Mr. Speaker. We're not buying that. Neither is British Columbia.
It is pretty puzzling that our Premier right here in British Columbia had no idea what is going on in his backyard with this federal agreement with the Musqueam. A lot of concerns that were started over Cowichan, and now it seems like we're getting the limited amount of information, and people just want transparency in British Columbia after everything that's gone on with private property. And another thing, Dre, that really needs to be addressed is that area is one of the busiest economic corridors for transportation in British Columbia and in Canada for that matter. I think we need to get some guidelines. Will that be affected? What is the repercussions of this deal? And what's going to happen moving forward? I think British Columbians deserve to know from this Premier, David Eby, what is at stake. And it can't be another situation like it was with the Cowichan deal, where we're going to find out months later all the effects that's going to have on British Columbian lives.
But when it comes to private property rights, everybody is worried, especially after what we saw happen in Richmond last year with the Cowichan Canada decision, where the Supreme Court of British Columbia said, yes, Aboriginal title does supersede fee simple title, your private property titles. And we're still waiting to see how those appeals pan out. We've covered that extensively at endlandgrabs.com. So naturally, everyone is wondering what is happening here in this mass area of part of Greater Vancouver. Today, I interview a Aboriginal law expert, Thomas Isaac, who is the partner in the business law group at Castles and serves as the chair of the firm's Aboriginal law group. He even wrote this book on Canada and the United Nations Declaration on the Rights of Indigenous People, UNDRIP, which was adopted as DRIPA in British Columbia to conform all of our laws with that aspirational framework. Mr. Isaac is going to speak to us about these concerns with private property rights in this new agreement and how, when it comes to whether or not they're protected, it's not that simple.
Well, you may have heard the Government of Canada and the Musqueam say that private property is not affected by the agreement. I can't say that. What I can say is I don't know if private property is affected by the agreement, and that's not a good answer. We should be able to know one way or the other. The reason I say that is that the Musqueam asserted territory is very, very large, and the Government of Canada has agreed that the Musqueam have Aboriginal title within that territory. It does not define precisely where they have the title. Is it in Vancouver Harbour? Is it in the British properties? Is it in the more remote watershed areas of that territory? So for anyone to say that it doesn't affect private property, there is absolutely not a word about that in the agreement. And I'll just say, if I could say one other thing, they could have excluded private property from the agreement. If that's what they intended, this gets real simple. This isn't rocket science. You excluded from the agreement. They chose not to. So they cannot give the assurance that private property is not affected. It's simply not accurate.
You're right. When I heard the claims, don't worry, it's not about private property, I thought I was going to see that exclusion, and I didn't. Something else I saw there was this talk about the scope could later be discussed. What exactly does that mean?
I don't know. Okay. So it's very concerning. We should know. You should have at least an idea when you're dealing with constitutionally protected rights and, you know, the second or third largest economy in the country. So one would think you'd want to be very, very specific about what you're agreeing to, especially regarding co-jurisdiction involving 1,400 citizens of Musqueam dealing with 2 million people in, well, at least what used to be a vibrant economy, but in a large economy.
If this truly wasn't about private property rights, what would be the point? What would be the point of getting Aboriginal title?
Well, look, Aboriginal title is a big deal. I want to be very clear about that. It's the constitutional right to land. It is not an interest in land. It is the land. The Supreme Court of Canada said it's no longer Crown land. The Crown doesn't even retain any of the benefits from the land. So when we talk about Aboriginal title, everyone needs to understand, according to the law today, not what people think the law is or what they might want it to be, what it is today is absolutely very clear. So look, it's obviously very beneficial for a First Nation to have Aboriginal title affirmed over small discrete parcels. But when you start talking about occupied areas and settled areas of a province, any province, that's really got to be a non-starter if we're serious about reconciliation.
Speaking of discrete, that's a big issue with everybody, how discrete these agreements were. And people are also thinking, of course, of the Cowichan decision. You're an expert in Aboriginal law. Have you seen something like this before? Is this surprising you as well? Look,
unfortunately, there have been many times when we see some secret agreements done. But on the order of magnitude of like the Haida agreement last year, for all of the Queen Charlotte Islands, now this agreement, it's shameful. It's absolutely shameful. And to think, if in fact the Premier and Provincial Minister of Indigenous Affairs are in fact being accurate that they were not consulted, we've now had a federal government come into a province, declare title on provincial lands. So remember, all of these lands, save and except for reserve lands, there'd be a few reserve lands included. These are provincial lands. The federal government has no authority to do that. What did we hear from the Premier today? We'll give this some thought. We'd like to read the agreement. They should be deeply offended that the federal government would dare to do this unilaterally.
Anything else you think is important for the public to know?
Well, look, I think it's noteworthy that the Squamish Nation has just issued a press release stating that they weren't even consulted. To say I'm speechless again, I mean, it sounds hyperbolic, but I don't know what the end game here is. And I said on my LinkedIn post today, I feel like we're near our last breath. I don't know how much more the BC economy can take of this. And these are self-inflicted wounds by our democratically elected governments.
At Rebel News, we have been letting you know about reconciliation overreach for years and how people's good intentions are being used in a way that's not good for all. If you want to take action against land grabs, go to our special website as a way to start doing so. Sign and share our petition at endlandgrabs.com.